I'm going to go ahead and get started here. Welcome everyone. This is the Tucson Metro Chambers Knowledge at Noon. I am your host, Carol Gatewood. I am the Special Projects Director at the Chamber. I am really pleased today to introduce you to Abbe Goncharsky. She is an attorney, a mediator, and an arbitrator. She is an experienced labor and employment counsel, and she also works with human resources. So please welcome Abbe, and she will start our presentation today.
Good afternoon, everybody. Welcome to this seminar. Today we're going to talk about the federal state laws that you're looking at, and really with an eye towards how do you use those laws now so that you can prepare for what's coming next for your business. So I do have a prepared PowerPoint, but I generally assume that people attend webinars because they have questions that they are hoping to get answered, and I am happy to keep an eye on the chat function, and as you have questions, just let me know and we'll make sure that those get addressed as well. I'd rather you leave here with your questions answered as best as I can versus my telling you what I think you needed to know, but what isn't very helpful to you. So let's start just so you have another idea of what I look like when I'm a little bit more dressed up for the day. I am an employment and labor attorney. I've been based in Arizona my entire career. I have almost 2 decades of experience. I work with 4 nonprofit employers of all sizes, all different types of industries, making sure that they are taking care of their employees to the best of their abilities and evaluating risks, and that when things go awry that we address them as well. So we've been keeping pretty busy the last several weeks, making sure that we're doing everything that we can be. Just a reminder, in case there was a question of whether I'm really a lawyer or not, today's presentation, question and answer are provided for informational purposes and a courtesy only. We don't have an attorney-client relationship. Even if you are one of my clients, today's conversation isn't going to be for legal counsel. I do encourage you to talk with employment counsel about your policies and processes, particularly now when there's so many questions. We are focusing on a bill that took a few days for them to get passed, and then our poor friends over at the Department of Labor didn't have very much time to put together some regulations. There's some sort of interesting typos and things that'll have to get corrected in those regulations that came out 2 days ago. So we'll just keep working through here, but just so that you know, all of this is information only, not legal counsel. Today's agenda, I think we'll talk a little bit about the key existing and new laws that you should know about. Lots has been made in the media as far as the Families First Act and the CARES Act, so we'll talk a little bit about those. Talk about the options that employers could be considering right now, both how do you get through this, what we hope is a short-term situation, and then how do you plan long-term and look to the future. And of course, a question and answer session at the end. But particularly because it's a webinar and so I can't tell how your reactions are, how you're feeling about everything. If you have questions as we go, I am all for that sort of conversation approach as opposed to it being literally my sitting in a room by myself talking to myself. I will fully admit that maybe there's days that I do that too, but that's a whole different thing. So the new laws that we're considering, we have the Families First Coronavirus Response Act, which is a very long name and doesn't abbreviate well at all. And then we have the Coronavirus Aid, Relief, and Economic Security Act, which they did a nice job, abbreviates to the CARES Act. We have the governor's order regarding unemployment, and then the governor's later order regarding stay at home. We have mayor's orders regarding essential businesses to complement the governor's order. There's a lot for employers to be thinking about. My plan is to focus on those 2 in bold. I know a lot of businesses are having to evaluate maybe the terminology isn't great, but how essential their business is, how essential each individual of an essential business is, who needs to be going into work and who can be doing work from elsewhere. So let's start with the Families First Coronavirus Response Act. Covered are employers with less than 500 employees on the day that the leave starts. So to calculate who is eligible as far as an employee, you look at those who've been on payroll for at least 30 days. Possibly small businesses will take an exemption. That means if you have less than 50 employees, you can take an exemption so that you don't have to provide paid sick time for certain purposes. Same with healthcare workers and same with emergency responders. Concept being small businesses would suffer a dramatic impact potentially if there were issues as far as not having enough people to make the business run. And then we need our healthcare workers and our emergency responders as a day-to-day for our society. So there's two forms of leave. We have the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act, which I was just talking with somebody yesterday. I wish they'd picked a different terminology for that. I think it's confusing a lot of people who are smaller employers, don't have what we call regular FMLA these days, but they do fall subject to the Emergency Expansion Act. Just to be clear, the law took effect on Wednesday. It seems like a really long time ago to me now. I don't know about you all, but Wednesday the 1st seems eons ago. And it does come with it some tax credits to offset the costs that the employers will face. So just to run through them, there are 6 qualifying reasons, 3 of them related to the individual, so that an employee would be eligible as long as they are working for a small enough but not too small employer to take leave where they are subject to a quarantine or isolation order that's been issued by a federal, state, or local government. They have been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, or they're experiencing COVID-19 related symptoms and they're seeking a medical diagnosis. Thanks to the regulations that should take effect on Monday, the proposed rule is out. We now know a little bit more. We know that quarantine and isolation orders do include the stay-at-home order, so that causes a whole bunch of questions for me and the employers I work with as to what that looks like in Arizona right now. We know that healthcare provider has a very, very broad definition, and we also know that that you can ask certain questions to be able to document an employee's requests here, but there's very specific requirements as to what you can and cannot be asking. The 3 other reasons that we have are that the employee has a bona fide need to care for an individual who's subject to quarantine, either pursuant to the federal, state, or local government order or the advice of a healthcare provider. We now know also that that is not just a family member, but it's somebody for whom the relationship is such that we would expect that you would care for the individual, which is a very interesting, very squishy sort of definition there. But I think intended to be, do you have a family-like relationship? They very specifically also talk about, do you share a residence? So if it's a roommate, maybe you need to take care of that person because you're the only person who could care for them if they're ill. We have a lot of discussion going on in Arizona because our schools are closed for the rest of the year, that the employee needs to care for a child who's under 18, whose school or child care provider is closed or unavailable for reasons related to COVID-19. That includes child care providers where it may be a little bit less of a formal relationship. So that's also an interesting dynamic that we have going on there. And then the 6th one, I'm not really sure what to do with it right now. Nobody really is, I don't think, that the employee is experiencing a substantially similar condition. And then it's as identified by the Secretary of Health and Human Services and Secretaries of Treasury and the labor folks, and not really sure what that means, but we'll leave it for there. So what it means is that for full-time employees, they'll receive 80 hours of paid sick time if their employer is eligible, providing the leave, and then that they've been working for 30 calendar days. Part-time employees receive paid sick time equivalent to the number of hours that they would average over a 2-week period, and the rate of pay is to be determined by the reason they're qualified for leave. So if you're unable to work due to your own illness or a quarantine order, you can receive up to $511 a day and $5,110 in the aggregate. If you're unable to work because you're caring for somebody else, that's up to $200 a day or $2,000 in the aggregate. Question that I received in a different session is that if an essential employee is only able to work part-time because the daycare is closed, does that employee qualify for the sick pay to cover the difference in pay and complete the 40 hours a week, which is a great question. And the answer that we're looking at is the Department of Labor says yes, that if your employer has you scheduled for those hours and you're unable to work or telework to fill out what schedule you have, that's when you can request paid sick time. It would be for reasons like caring for your children, because you would be basically working part-time and taking care of the kids or doing something else. We wouldn't want it to be intermittent time where you are sick and so you're going into work for 3 hours a day while sick and then going home the rest of your day. That's not what this bill is supposed to cover, and that's not the benefit you're supposed to be getting out of it. So makes sense to me, but I think it's a complicated thing to wrap your head around as far as being able to provide it. I have a couple clients who've really struggled with the fact that they are providing telework to people, and people are still saying, but I can't get my work done because the kids are home. And so making those schedules work we've gone from 9 to 5 to some folks are working 4 to 8 a.m. Then they take care of the kids for a period of time, and then they're back online later in the day, and then there's some paid sick time in there. Really what the Department of Labor is saying is please be flexible with your employees to the extent that you possibly can, because the benefit is that we have provided you these tax credits. It should be helpful to the employer. Keep the employee as actively employed as you can, and then you have the tax credits to cover the expenses that you're incurring on top of that. FMLA expansion continues this. So paid sick time is only for those 2 weeks. FMLA expansion for the employees who have children whose schools and childcare facilities are closed, employers actually have to provide a total of 12 weeks of job protected leave. This is not in addition to regular FMLA. So if you are already qualified for FMLA, if your employees are qualified for FMLA, they get a 12-week total, which means, as I read it, if they have already taken 12 weeks earlier in the year or earlier in your 12-month period, if you have a rolling 12 months, they are currently not eligible to take the child care leave. That's going to be a difficult conversation to have with some employees, but that's where things are right now, that this didn't become a 24-week period. What's different about this type of FMLA, and where some employees may get cranky if they've already taken regular FMLA, is that while weeks 1 and 2 remain unpaid, except you could use paid sick time, weeks 3 through 12 are paid. So generally at 2/3 of the employee's regular pay and up to $200 a day and $10,000 total. Question from some folks is, how do you handle the cash flow here? Again, it's based on the tax credits. So as long as you have the ability to float to be able to get the tax money back, you'll be able to make this all work out. But I understand some people just don't have that much in the bank, and that's where looking at loans and credit lines and things like that are coming in on a regularly day-to-day basis at this point. Adding into COVID-19 and the regular FMLA, as I'm calling it, because I don't know what else to call it right now, that still only applies to the employers who have more than 50 employees, right? So if you are a small business, you do not suddenly have regular traditional FMLA. If you have an employee with a serious health condition, something like that, we are not asking you to suddenly provide them with 12 weeks to care for themselves or somebody else. What we are saying is that you need to provide the 12 weeks for somebody who needs to care for their child because school is closed because of COVID-19. And just to reiterate, it's only 12 weeks in a 12-month period, not including the time that's taken under the Paid Sick Leave Act. That is a different situation. Any questions so far? Doing okay? All right. So the CARES Act is the $353 billion that's been set aside for the Paycheck Protection Program. That was supposed to be released today. Some of the regulations and instructions came out yesterday, and I've seen a flurry from business lenders this morning saying, Chase started it yesterday saying there is no way that we're going to be accepting applications on Friday, April 3rd. Several of the others followed to say, we're doing this as fast as we can, but we are not in a position to be able to take applications right now. The applications, so that you know, you'll have to fill out some documents through the SBA. We also know that likely the banks, the lending organizations will also have their own applications and document requirements. We know that loans will be capped at $10 million each. The loan amount is going to be based on 2.5 times the average total monthly payroll costs. It's supposed to be used for things like payroll support, salaries, paid sick and medical leave, insurance premiums, mortgage and rent, interest, and then utility payments. So the idea is that after the funds hit your account, and signs still look promising that the funds will hit your account within 48-ish hours after this all happens, that you then start an 8-week clock ticking. That during those 8 weeks, whatever you spend in payroll and mortgage and rent, the qualified expenses, that amount will be forgiven so long as however many employees you had on February 15th, you still have that number of employees on June 30th. Issue is, all of this started in March, and so there are a number of organizations that have let people go or have significantly reduced hours between February 15th and where we sit here. What the law also says is that if you increase back to the levels pretty rapidly, that then you will also be eligible for that forgiveness. Interesting here, the nonprofits are also eligible. That's not always the thing that we see with SBA loans. And the goal of the program really is quick approval, that we want to see if we can get this money back to small businesses and keep them going. All right, still talking to myself. You guys have any questions, let me know. Other laws that you should be considering right now as we start looking towards the future, the Fair Labor Standards Act and the Arizona wage statutes. So talk a lot about how we're reducing hours and we're reducing compensation for employees so that then we can keep a cash flow going and be able to keep the employer, the business moving forward long term. Don't forget though that there is minimum wage requirements, and then if you have exempt employees, you need to make sure that you're still paying them the $684 a week as a guaranteed salary. What I'm seeing a lot from employers is that the question mark now is whether those exempt individuals really are performing jobs that warrant an exempt salary. And so keep an eye on that. If because the business has slowed down, for example, in a restaurant, you're keeping the general manager and the chef and a couple other people on, they may no longer be managing the number of employees required to remain exempt. You may need to move them into an hourly position to get through this and then come back. Saw a question come through in the chat. So if we go back to FMLA, folks who took the 12 weeks for maternity leave in early 2020 are out of luck for sick time at this point, correct? They are not out of luck for sick time. Remember, there's the two different acts. So we have the Paid Sick Time Act and we have the expansion of FMLA. They are out of luck for the FMLA if you work on a 12-month rolling period or you consider it in the calendar year. However, they're still eligible for that paid sick time for the 2 weeks that they could get, as long as they would need to care for the child because the daycare is closed due to COVID-19 related reasons. Let me know if that doesn't make sense, Selena. We'll keep on talking about it, okay? All right, so I'm glad. Okay, so two families who had this question, absolutely. Yes, it's that frustration, and I'm certain that they are beyond frustrated that they've already taken their 12 weeks. It's already April, so it's entirely possible they have completely taken their 12 weeks at this point. Those 12 weeks were unpaid. Now they find out, had they not taken those 12 weeks, they could have gotten some of that paid. It has to be incredibly frustrating. We just didn't have the law in effect at the time to be able to make those sorts of decisions. All right, continuing on with things to be thinking about. We also have the Arizona Fair Wages and Healthy Families Act. Remember, that's the earned paid sick time that we spent a whole lot of time talking about in 2017 after it was passed as a ballot initiative, Proposition 206. And part of our conversations back then, I don't know if you all will remember, but in 2017, we spent a bunch of time talking about who's going to take paid sick time because of some sort of public health emergency that closes schools. What could possibly happen that would find us there? And there's just irony for me of, I go back and I listen to the webinars from back then of we now find ourselves there 3 years later that we have a public health emergency that closed the schools. So to the extent that you have employees who prior to April 1st were asking for time off, they should have been looking at whether that was earned paid sick time that they could be taking. Also keep looking at it too. Your employees don't have to take the emergency paid sick time. You don't have to tell them to take that. They also don't have to take earned paid sick time under the Arizona statute. Give them the option of what it is that they want to take and see where it goes from there. My expectation with most employees is they're going to give you that look of, I don't know, you tell me what I should do. I work with a lot of employers who have employees who do exactly that of, Miss, I appreciate what you're saying, but I have no idea what the answer is. So can you just tell me what the answer is? And I would just put together in your policy some sort of a default. If you identify a qualifying reason, this is what we're going to do first, unless you tell us otherwise. Something along those lines. OSHA. So we also have OSHA to consider as we're in the mix here. We have making sure that our employees are safe when they're at work, right? So we have a whole lot of essential businesses that are continuing to function, making sure that those employees are keeping a safe distance, provided with the necessary PPE that they might need in order to do their job and to do their job safely, considering the circumstances where we find ourselves. The media is starting to pick up on some interesting stories about different employment situations and whether the employees are getting what they need. I don't know about you, but I always read those stories assuming that there's at least one more side to the story than what we actually know. But things to think about. OSHA has issued a couple publications talking about COVID-19. Right now, their position is mostly that they've told you how to keep your employees safe. They've told you what the requirements were long before COVID-19 was ever an issue, and you need to be in compliance with that. They do believe that they have enforcement authority if they think that somebody is not being kept safe in the workplace. I've seen a couple articles and a couple situations where we did have OSHA or one of the state agencies show up to shut down the entity. So we want to be careful there that that's not a circumstance where you find yourself. Title VII and the associated EEO laws. The EEOC did a webinar on, Friday, March 27th. They published, it was a pre-recorded webinar that they put on their website. It's an interesting listen. They go through Q&A and talk about particularly the impact of COVID-19 on the Americans with Disabilities Act and the state equivalent, that you want to make sure that you are providing leave and reasonable accommodations to individuals with qualifying disabilities, whether or not they are then eligible for earned sick time under the new law or the expanded FMLA. So in particular, I've seen a couple of healthcare providers writing notes, received one about an employee that had pre-existing anxiety. And so the situation in which we find ourselves was creating even more of a medical situation for them. And the doctor's note did say that they needed to self-quarantine for the 2 weeks in order to be able to address the medical condition that they have. I think the EEOC probably would take the position that that was a request not only for the expanded paid sick time, as long as the documentation was provided and met all of the standards there, but that it was also a request by an individual with a qualified disability for a reasonable accommodation. And then you have to go through the ADA analysis there. Workers' compensation. So I've been working with a couple entities as we work through furloughs and things like that of, does workers' compensation cover? How does workers' compensation cover? More so for me, the concern is, I mean, I'm looking at a bunch of you sitting in your home, we'll call them offices right now. I actually do work out of a home office more often than not, but I know a lot of people are in a new situation here. Does the employer's workers' compensation policy cover you if you get injured while you're working in your quote unquote new office? So I have had workers' comp cases of remote employees who, I don't mean to make light of it, but got up to get a glass of water, so arguably no different than in a regular business situation, and tripped over the cat and then made a workers' comp claim because they got injured from that. So making sure, if you are the business, that your workers' comp carrier is going to provide you the coverage, and that do you need to be providing any direction to your employees, right? So I don't know if you've seen them. I've seen them on Instagram and a couple other places. The feeds where people take a picture of where they're working, and some people are working in reasonably lovely spaces and other people are crammed in a folding table, you know, sitting crisscross applesauce in the corner, making sure that they're instructed to be ergonomically appropriate to the extent possible, etc. We've done a pretty good job societally of getting rid of things like carpal tunnel. I would hate to see them come back because people are sitting in uncomfortable positions for too long during the day. And then always we have the WARN Act that requires notice to employees if you're going to do a mass layoff. There is a provision that says that, quite frankly, where something like COVID is unexpected, you may need to shut down faster than you can give the 60 days notice, but there are still steps that you would want to take to make sure that you're compliant there. All right. No, it's not clicking. There we go. All right, so that's sort of the legal side of where we're at. What I like to talk about is, where do we go from here? How do we use the law to make it so that you can run your business better? How can you, in this instance, figure out not only what you need to do right now, but when we are back, when the stay-at-home order is lifted, when people are back interacting with each other in person, using all of the businesses available, what do we do? So I made this list of options to consider. I am considering it from the quote unquote easiest to the quote unquote most difficult to implement, recognizing that there is not a single part of this that is easy for anybody that I have talked to, whether their business is continuing to operate as usual or not. I think everybody is dealing with something here. So there are businesses that can just continue to be business as usual. Some entities are even seeing an uptick in the workload and the work to be performed. That becomes a plan though of, if there is more work to be done, how do you make sure to keep your employees safe? How do you make sure not only to keep them safe, but to make sure that they are getting the mental rest that they need in order to be able to be effective and efficient at what they're doing, providing all of that. Then continuing though, hiring freezes. So you're operating business as usual, everything's great, but you do need to keep an eye on your cash flow. Maybe you put a hiring freeze into position. Maybe you say that, you know, to the extent that we're planning to do some promotions and some transfers, that's not going to happen right now. We need to keep an eye on things. So any promotions are on hold for right now. Business modifications. It's a great opportunity right now that employers have to take a look at their businesses and see if they are running as efficiently as they can, if they have the right people in the right seats, if they have the right responsibilities assigned to each individual. Limit non-essential overtime. So if you have non-exempt employees who generally work more than 40 hours, now might be the time to tell them that you don't need them to be doing that. See if you can reallocate some of the job responsibilities or even just eliminate them right now, so that you can keep an eye on the costs. Reductions in hours, I'm seeing a lot of, where somebody was working 40 hours a week, but we really only need you 24 these days, or even less than that. Something to take a look at is DES does have the shared work program, which they've made a couple of revisions to in light of COVID-19. Gives some employers some benefits there. And it's just one of those things that's sort of been in the background for a long time. With the economy going where it was, we didn't have a lot of employers looking at it. It might be something to take a look at for employers now. Oh, and then along those same lines, if you reduce hours, they may be eligible for partial unemployment. So making sure that to the extent that it's your culture that you do let employees know we are having to reduce your hours, we do think it would be worth your going to DES and applying for unemployment. I know that's not something most businesses usually say out loud, because it affects your rating and for some other reasons. Here we have an order from the governor that it's not, or we actually have a bill signed by the governor that it's not going to hit the same rating, that we are going to have some sort of a separate program to address the COVID-19 claims that we're seeing here. And then also you might be eligible for paid leave on a partial basis under the Families First Coronavirus Response Act. So keep that in mind too, that it may be that you have an employee who is balancing a whole bunch of different things, caring for somebody else, caring for a child, caring for themselves, plus trying to get all of the work done. It may be worth talking with them. If you reduce their hours, they arguably aren't eligible for the benefit, but if they're up front and they say, look, this is just too much for me to be taking on right now, can I take some time? That might start the conversation and make them eligible for the leave and the business eligible for the tax credits. I'm definitely not saying try to flaunt the system by any stretch of the imagination. The idea of aggravating the IRS is very, very low on my list of things that I would recommend to anybody ever. But I think here there is a lot of guidance from the DOL saying as much as you can work with your employees and try to provide them all these benefits. I think if somebody says to you that they want to reduce hours and it's useful to you and it could help, it's something to look at. And then we also have prospective reduction of compensation. And it's important to emphasize the prospective, right? We're not going to go back and reduce somebody's compensation from Q1 or anything along those lines, but you could reduce somebody's compensation starting next week as long as you give them notice so that they know when they're performing the work, the amount that they'll be making while they're performing the work. Keep in mind if you have any employment agreements or other documents that may be contrary to any of this, that you do need to take a look at that and figure out how you can modify the situation in order to be able to do that. So again, with the prospective reduction of compensation, they may still be eligible for leave under the Families First Act, but they might not be eligible for unemployment. I generally say it's worth going to unemployment and filling out the paperwork anyway, although I understand right now the online system is a little bit overwhelmed. So it may be a frustration to suggest it to some individuals, but it also may be feel like a power move as far as being able to start the process and get in line, basically. Then we move into the more difficult, I think, as far as thoughtfulness and culture types of things, the furloughs, which are also seen as temporary layoffs. That's unpaid leave for a limited period of time. Limited period of time is generally thought of to be less than 6 months because that's when WARN starts to kick in. Hopefully we are not looking at something that is that long, but they would be on unpaid leave and then you would recall them if there's work. During that time, the employees may seek unemployment benefits, and as long as somebody makes it clear to unemployment that the reason that they're seeking the benefits is because of COVID-19, the expectation is that DES is going to waive the 1 week waiting period. So again, one of those things that when you are informing employees about the unpaid leave that they'll be taking, probably a good idea to let them know that here's how to get to DES online and here's how to fill out the paperwork. I have a lot of employers too that as they're preparing the furlough paperwork, they're also working on the 1 or 2 sentences that they'll put on their responses to DES so that they don't have to be thinking about that at the time. They're just ready to go. The FFCRA benefits are not available to employees who are furloughed. So if you are on a furlough, remember we talked about how if you don't have any hours available with the employer, you are not eligible for the benefits. If you're furloughed, you don't get the benefits. But the benefit of furloughs for an employer is that they are already your employee. When the work returns, you pick up the phone, you call them and you say, I look forward to seeing you. I would suggest in a couple of days, you probably don't want to call somebody at 5 o'clock and say, see you tomorrow morning. As much time as you can give them to get ready and make arrangements to come back. But they are already your employees, so the expectation would be that they would return to you. And then with the way that we've set things up with unemployment and DES right now, employees don't need to be looking for another job while they are on unemployment. So that's a nice provision for employers not to have to worry about what happens with their employees during a furlough. Layoffs are more permanent. It's a termination of employment and benefits. The employee becomes COBRA eligible, where furloughs, for the most part, I'm seeing medical plan providers, healthcare plan providers saying that they will cover employees who are on a furlough as long as somebody continues to make the payments on the premiums. With a layoff, with an actual termination of employment and benefits, you would go into a COBRA situation. If your policy requires it, you need to pay out the PTO. Most policies I write anyway have at least some caveats on not paying out PTO, particularly in the circumstances where we find ourselves right now. I don't know if paying out PTO is going to put companies in a great position, but something to think about. It definitely would help the employees, and that's always a consideration as well. The employee will be eligible for unemployment, but keep in mind, because you've terminated them, they might find alternate employment, or you would need to rehire them, fill out all of the new paperwork, et cetera, when they come back. And they would not be eligible for the benefits under Family First. PTO wise, I would definitely be thinking about what does your PTO policy say right now? Do you have to allow the use if requested, assuming that you're continuing to operate the business? Have you thought about suspending its availability? So if you're running the business because you have so much work that needs to be done, can you, as a business, tolerate people taking PTO right now, or do you need them to be in the office or at work, wherever work is, in order to be able to get things done? But again, don't forget Arizona EPST, that employees can be taking Arizona's paid sick time right now with all of the burdens and benefits that provides to employers. Other things to think about, we talked a little bit about the WARN Act already. Think about whether you have employees who are union represented. You'll have a collective bargaining agreement then, if not more than one, where you'll have to think about what the terms are before you go through anything of what I've just talked about, of layoffs and furloughs and reductions of hours and compensation. You probably anticipated a lot of that in your CBAs. You need to make sure that you're thinking about that. Probably one of the bigger complications are employees who are on visas right now. Because there are very specific restrictions on what you can do with limiting hours of an employee on a visa. I also have a couple of employers who are in a situation where their visa employee had decided to travel in, say, late February-ish, and they are now not able to get back into the United States. So now what do we do with those employees? How do we continue to maintain them? How do you work with the visa? Definitely something to flag if you have managers who aren't aware that the employee is on a visa when they're thinking through some of these decisions. Workers' comp claims, I'm definitely seeing a rise in requests for workers' comp. Seen several employees saying, well, if you make me come to work, I'm going to file for workers' comp if I get COVID-19. My general response is okay. But that's my response always to somebody who says something about workers' comp, that of course you can file for workers' comp, it's your right to do so. And generally if the carrier then handles it, it's out of your hands, right? So statutorily, if you have a workers' comp policy that covers that employee, the statute says that workers' comp is their exclusive remedy for the harm that's been done to them or that they allege to have been done to them. That's a nice thing. And then the unemployment claims, think about whether you want to enter into the shared work program, something along those lines. So what comes next? I like thinking about the future. I don't know about you. It makes me feel a little bit better about where we find ourselves right now. So I think that a lot of employers are seeing whether alternate work conditions actually work for their businesses or not. I am concerned for my clients who are in commercial real estate right now. I think that as people are realizing that they do have the ability to be more flexible in locations, we may see some employers deciding as their renewals come up that maybe they need to shift the way that their spaces are allocated, look at really figuring out what works for them. Do they want to provide some more flexibility in workspace? Does that include telework and remote access, or even just the ability to move freely within a space? I also think we went to more open concept, shall we say, living as we moved through spaces for work design, and that became more problematic as we were starting to work on social distancing. So some of my employers that have a lot of employees in cubicles or something like that, it was a lot more difficult to be able to make sure that employees would be feeling safe while they were at work, whereas individuals who could go into an office and close a door, there was a different dynamic there. So something that we may see employers thinking about, definitely something to be thinking about as you envision what this looks like 6 months and a year and 6 years from now. I think we'll see more cross-training, people being able to do other people's jobs for flexibility. Things to think about now, right? Do you have employees who could be working on cross-training from home so that then when they come back, they can hit the ground running? Might be useful to you and to them. Rehiring decisions or just recruitment decisions as a whole. Do you have the right people for where you think your organization is headed? Do you have ideas as to what you would want them to be doing and how they would be doing it? I think we will see some reorganizations and some permanent reductions in force, unfortunately. Oops, excuse me. I think that as we look at the numbers and as we look at the cash flow, I think we'll have businesses just say we can't continue to employ as many employees as we have, and we don't really have a choice in all of this. That we'll see some changes in operations as a result of that too. Just one moment. Sorry about that, a little stuck in my throat. We'll see some changes in operations. We'll see individuals or organizations start thinking about what it is that they want to do and how they want to do it going forward. And then we'll see crisis planning, I think, will become a very big focus of organizations of what did we do great this time and what could we do better next time, so that there is more of a plan, as opposed to what I saw in some organizations of people, IT working 24 hours a day to get people set up on laptops and things like that in order to be able to keep the business running. That we'll see folks start to work through there. All right, so I have a few questions that I had received in advance, but I have another question first from the chat. Mentioned that we're thinking about more cashless transactions, so not handling credit cards, buying tickets online, things like that. I think that's a great idea. I definitely think that's where society as a whole is probably going to be looking. We have a lot of people who had been declining to use things like Apple Pay and others because they just weren't comfortable and didn't need to learn how to use it because it wasn't a thing in their world, but now have to figure out how they can work through that, even when deliveries are made, the delivery individuals are not coming within X amount of feet, and so transactions that have to do with cash is pretty complicated. As far as lessons learned, thoughts on how businesses can protect themselves more in the future, I think that planning for the worst is always helpful. It's how I approach my practice with my clients, to say, let's think about the worst case scenarios and plan for them. Hope that none of them come to fruition, have some alternate plans as well, but we always want to have that plan in mind for what could happen. So I spent a couple of years working for Mr. Car Wash, where we had locations all over the place. And one of the things that we would work on is things like, what if there was a horrible storm and we couldn't get paychecks to people as live checks? Things like that, where I think companies are starting to see that now, even in Tucson, of if you have individuals who have live checks right now, how do you get them their money? Obviously, you could put a stamp on it and put it in the mail, but we know that it's going to take them at least 2 days to get it, because it goes from Tucson up to Phoenix and then back again. If somebody needs to make their rent payment, that might not be timely enough for them. So I think that we'll see companies starting to think about things like that. We're also starting to see the lawsuits being filed about business interruption insurance. The carriers are denying claims on business interruption insurance, saying that this is effectively an act of God, and so it was excluded from the policies. And I think that we will see some interesting litigation there. I think the lawyers have been pretty smart as to the different places where they filed the cases, depending on whether it's the insurance company or somebody seeking for some coverage. But I do think that having processes in place there makes a lot of sense. I also think we're seeing a lot of businesses saying, this is why we had our rainy day fund, or I wish we had had a rainy day fund. So companies that are living a little bit closer to the line as far as how they spend their money and where they spend their money, some decisions may just have to be made, if that's something that can continue or not. All right, so example question 2, an employee brings in a note from the doctor saying self-quarantine until the COVID-19 concerns are lifted. We talked about this a little bit. If the doctor relates the concern to another health consideration, such as asthma, I think you probably have an ADA consideration on your hands, as well as the new paid sick time. I think you need to take a look at both of those and provide those. I have employers who have implemented very specific policies for their employees, all the way through employers who put the posters up and said, these are the new laws, let us know if you have questions. This would be something I would address more as a protocol for whoever's handling these requests, to make sure that they can adopt it. And then what happens if the employee is newish and doesn't have the kind of job that facilitates telework? You're going to have some difficult considerations here. I think it's paid sick time for the 2 weeks, and then figure out what's going to happen next. With the stay-at-home order, if you're a non-essential business, I have a feeling that that employee just doesn't have work to do until everything opens back up again. But I would use this too to plan ahead, right? Of what would you do next time? Are there ways that you can create more work from home opportunities for individuals? Or do you want work from home opportunities for individuals, right? I also have a lot of employers who are struggling because those employees that weren't necessarily the best employees in the office now are even more difficult because they are not in the office, and making sure that people are getting done what they need to get done on a daily basis is a bit of a challenge. So putting some policies together for what remote work looks like, and how do we handle remote work, and what do we expect from people when they are working remotely, always isn't necessarily a bad thing. If nothing else, I expect that everybody on this webinar probably does work from home from time to time. And should you have some sort of an agreement with your employer about what that looks like? The worst case scenarios are the situations where somebody has been working from home, has a laptop with them, has documents with them, etc., and decides that they're leaving the company. Now, how do we get everything back from that employee before they move on to their next employment? It can be an interesting challenge for employers to have to work through. Any other questions? All right, we also have the situation where what happens if the situation has to do with the health condition of a family member, and keep in mind that caring for an individual who's subject to a quarantine order is actually covered by the earned paid sick time. But if they're relating the COVID-19 self-quarantine to the health condition of a family member, I think it's a much closer call. So again, things to think about for the future. How would you make something like this work in the future? Even things like, I've spent the last 2 weeks talking with people whose heads are spinning because we have all of these new laws. How do you put in place a system that gets the key individuals the support that they need if there is a circumstance like this? And while I hope this is never repeated, there are major weather conditions and other situations that I think we probably can and should be planning for as businesses, so that we know that we have what we need in order to keep things going. So when I set up my firm 4 years ago, it was things like I made sure that everything's electronic and I have things stored in multiple locations, so that then if I ever did have to operate from a different location, it's easy enough for me to keep doing that. That is not always as easy to replicate. I know I work with businesses that do manufacturing and production and things like that. Obviously, you cannot take a factory and move it and just keep going. It's the circumstance where we find ourselves right now and working with those individuals. But what of your company can you make so that you can make it a little bit more portable, a little bit more flexible? And really, what is it that we could be doing, and how could we be doing it in order to make things easier on all of us going forward? Question is that furloughed employees can apply for unemployment immediately without the wait period. So there's a new bill that passed, and I wish I could tell you when it was, but I know it was in the last week or so, that directs that my understanding is unemployment is to issue the benefits immediately without the week wait period, so long as they are subject to COVID-19, and that's why they are furloughed, so that you can go from there. Any other questions?
So we don't have any more questions. I want to thank everyone for joining us today. We have another Knowledge at Noon on Monday, which will be Pima County One Stop. Their subject will be laid off and furloughed employee services. So please join us for that. And if you'll see on the screen, Abby's contact information. So if you have questions, you can give her a call offline or email her.
Well, thank you all for coming. I appreciate the opportunity to talk with you, and I hope you have a great day and a really nice weekend.
Abby, thank you so much. Great presentation, good information.
Thanks, Carrie. Thanks, Carol.
Thank you, Abby. It was great.